In previous videos, we have learned that the Supreme Court has only extended the Equal Protection Clause to certain types of public discrimination. Discrimination based on race, alienage, national origin, religion, and to a somewhat lesser extent, gender. The Equal Protection Clause does permit many other types of discrimination, including discrimination based on disability. However, we also learned in previous videos that Congress has the power to pass laws to combat discrimination, due to its constitutional power to regulate interstate commerce. Using this power, it passed the Civil Rights Act of 1964. This law specifically prohibits both racial and gender discrimination, and in 2020, the Supreme Court decided that it also included gay and transgender employees. Congress has exercised its power to regulate commerce and has passed many laws that ban other types of discrimination, including many types that are not banned by the Constitution itself. Perhaps the most famous of these laws is the Americans with Disabilities Act, which is discussed in greater depth in another video. But there are several others. For example, in 1978, Congress passed the Pregnancy Discrimination Act. As its name implies, it banned discrimination against pregnant women, and it requires employers to make reasonable accommodations for them. One of the most famous examples of this law was brought by actress Hunter Tylo. Tylo was hired to play the part of what the producers called a sexy vamp on the hit TV series Melrose Place. But after she was hired, Tylo became pregnant. Producers said that a pregnant woman could not play the part of a sexy vamp, and they fired her. She won $5 million in the resulting lawsuit. The court said that producers could have made accommodations for her during filming that would have hidden her pregnancy, and that producers on other shows had done exactly that. Another federal law banning discrimination is the Age Discrimination in Employment Act. This act bans discrimination in employment against people aged 40 and older. So you can sue a company if they fire you, or fail to hire you, for being too old, but not for being too young. Recently, younger employees have been warned to not use the phrase, "okay boomer," when addressing older employees, for fear of an age discrimination lawsuit.
Whatever you say, boomer. Okay, boomer.
In 1963, Congress passed the Equal Pay Act. This law was designed to close the wage gap between men and women. It has clearly not been successful. Almost 60 years after its passage, the U.S. Census reported that in 2020, female full-time, year-round employees made only 83% of what their male counterparts made. In 2007, a conservative majority on the Supreme Court ruled that women who were victims of paycheck discrimination could only file lawsuits within 180 days of receiving their very first paycheck. This would have eliminated most lawsuits, because most women do not discover that they are being paid less within their first 180 days of employment. However, Congress passed a law that reversed this decision, the Lilly Ledbetter Paycheck Protection Act. It was the very first bill that President Obama signed into law. Women now have 180 days from their most recent paycheck to file a lawsuit. Thanks to the Uniformed Services Employment and Reemployment Rights Act of 1994, it is also illegal to discriminate against individuals based on their past or present service in the military. Congress also passed the Genetic Information Non-Discrimination Act in 2008. As the title indicates, this act prohibits employers, insurers, and others from discriminating against people based on their genetic information. For example, a company could not refuse to hire you if they learned that you had a gene that made it more likely you would get cancer, possibly leading to higher healthcare costs for the company. It is important to keep in mind that since all of these laws have been passed by Congress, Congress repeal any of them at any time. However, public racial and gender discrimination are prohibited directly by the U.S. Constitution. They do not require any laws to be passed by Congress, and they could only be revoked through a constitutional amendment. In addition, all states have their own anti-discrimination laws. For example, the state of California has laws that prohibit discrimination for all of the reasons covered by federal law. It also bans discrimination based on marital status. Furthermore, while federal law only covers all companies with 15 or more employees, California law applies to all companies with at least 5 employees.